the ATF is absolutely going to hate this.
All thanks to a massive exemption in the Hughes Amendment that we at GOA dug up and turned into a roadmap to shred the post-86 machine gun ban.
This is one of the most aggressive and constitutionally grounded state-level Second Amendment moves I've ever seen.
They have found the prohibition against machine guns unconstitutional. Not making it up.
With the exceptions, it says that a state can possess, transfer, or purchase newly manufactured machine guns.
Machine guns may actually be on the table for the legalization, at least as to brand new machine guns.
Here's something that's going to blow your mind. State and federal governments have always had the legal authority to transfer machine guns to ordinary citizens. Always. It's been sitting right there in the law this entire time. But nobody talked about it. Nobody acted on it. Until now. What I'm about to break down for you isn't some theoretical legal debate happening in academic circles. This is real legislation, introduced in a real state with real constitutional backing. And if it succeeds, the ripple effects could reshape Second Amendment rights across the entire country. West Virginia just introduced a bill that doesn't try to fight federal law. It doesn't attempt to nullify anything. Instead, it uses the federal government's own words against them. And honestly, the strategy is brilliant. Senate Bill 1071 landed in West Virginia's legislature with backing from one of the most aggressive Second Amendment organizations in the country. But what makes this different from every other pro-gun bill we've seen? It's not symbolic. It's not a statement piece. This is a calculated legal chess move designed to exploit language that Congress wrote into law back in 1986. Here's what the bill actually does. It authorizes and mandates the creation of a state entity specifically designed to purchase machine guns and transfer them to qualified, law-abiding citizens. We're talking M16s, MP5s, M249 squad automatic weapons. The bill orders state police to obtain, possess, and facilitate the transfer of these firearms to civilians.
Did you know that state and federal governments could transfer machine guns to us civilians?
Breaking news, West Virginia legislators have just introduced a GOA-drafted bill that would sell machine guns to law-abiding citizens.
They must be made before May 1st, 1986 to be transferred legally on a civilian.
A judge just did something that could send shockwaves through the entire gun debate. Just ruled that the federal machine gun ban is unconstitutional.
West Virginia might have just found the ultimate loophole to defeat the federal machine gun ban.
There's a litany of case law that obviously says that the Second Amendment protects all modern firearms in common use today.
Now, before you think this is some kind of legal fantasy, let me explain why this might actually work. Everyone knows about the 1986 Firearms Owners Protection Act. Specifically, everyone knows about the Hughes Amendment, which effectively banned civilian possession of machine guns manufactured after May 19, 1986. That's why transferable machine guns cost as much as a house. Artificial scarcity created by law. But here's what almost nobody discusses. The actual text of the law contains an exemption. Section 922, subsection O, paragraph 2 states clearly that the prohibition does not apply to transfers to or by or possession by or under the authority of the United States or any department or agency thereof, or a state, or a department, agency, or political subdivision thereof. Read that again carefully. Transfer to or by a state. Those 5 words are the entire foundation of this strategy. West Virginia's approach is elegantly simple when you understand it. If federal law explicitly exempts transfers conducted by a state, and if West Virginia establishes a state entity to conduct those transfers, then every transaction falls within the existing statutory exemption. This isn't defiance. This isn't nullification. This is using the law exactly as written. The state would create distribution centers authorized to acquire machine guns under state authority, possess them legally, and then transfer them to qualified members of the public. Every step happens within the framework Congress created. Think about what this means. For 40 years, Americans accepted that the machine gun ban was permanent and untouchable. But Congress wrote the exemption into the statute themselves. If they wanted to prohibit all civilian machine gun transfers with no exceptions, they could have written it that way. They chose not to. This strategy isn't just legally sound. It's historically grounded in the founding principles of this nation.
If you're in Texas, Missouri, Idaho, Arkansas, Montana, or anywhere else that is pro-gun, this can be a playbook for your state too.
What if the so-called Hughes Amendment isn't as airtight as they've told us for the last 40 years?
West Virginia is writing a bill to basically circumvent 9220. That prevents us from buying any newly manufactured machine guns.
But any new machine gun built after 1986, you cannot possess as a general matter.
But here's the thing. There are 740,000 legally owned machine guns in the US today.
This isn't a pipe dream. This isn't an internet rumor. This is actual legislation that attacks the very foundation.
Go back to 1792. The Militia Act of that year required able-bodied males to equip themselves with arms suitable for militia service. The government didn't restrict parity between citizens and military. They expected it. They demanded it. Throughout American history, federal and state governments sold surplus military arms to civilians. Springfield rifles, M1 Garands, even automatic weapons during certain periods. This wasn't controversial, it was policy. The founders envisioned a population capable of militia service. That meant possessing military-grade arms. The militia wasn't some government-controlled force. The militia was the people, and the people were expected to be armed accordingly. The Second Amendment doesn't protect sporting rifles. It protects arms, period. The Supreme Court's Heller decision established that arms include weapons in common use for lawful purposes. But here's where it gets interesting. The ongoing legal debate centers on whether machine guns are dangerous and unusual, which would exclude them from protection, or whether they're dangerous but common military arms, exactly the type the Militia Clause contemplates. That question has never been fully resolved in the post-Bruin legal landscape. Senate Bill 1071 could force that confrontation, and West Virginia might be the perfect state to do it. Here's where things get really fascinating from a strategic standpoint. Under our constitutional system, states retain sovereign authority. If West Virginia structures this action within federal statutory language, the federal government faces a dilemma. They would have to argue either that the exemption doesn't mean what it plainly says, or that the statute itself is somehow unconstitutional. Either path opens litigation, and litigation opens opportunity. The Department of Justice will have to make a choice. Do they genuinely support Second Amendment rights as they claim, or do they fight against citizens accessing arms that the law technically permits? This puts the government in an uncomfortable position regardless of which administration holds power. Courts don't interpret congressional intent, they interpret text, and the text says what it says: transfer to or by a state.
Guns are scary. Let's ban them. No, they actually have to prove that banning something is in line with historical gun laws.
For a federal law to be enacted, Congress has to enact it initially.
It is a bill that was introduced in West Virginia that uses the federal government's own words against them.
With the help of Gun Owners of America, West Virginia just introduced a bill that could completely upend the federal machine gun ban.
And so the way the court has been dodging the bullet, so to speak, is just to say, well, the Second Amendment does not even protect these firearms.
Let's think bigger for a moment. If West Virginia succeeds, even partially, other pro-Second Amendment states will take notice. Texas, Florida, Arizona, Tennessee, any state with strong constitutional carry laws and pro-gun legislatures could adopt identical frameworks. This is federalism working exactly as designed. One state tests a theory. If it survives legal challenge, others replicate it. The laboratories of democracy running experiments that could reshape national policy. For 4 decades, Americans were told the door was permanently closed. West Virginia just grabbed the handle. Whether it opens fully or triggers a Supreme Court showdown remains to be seen, but the attempt itself is historic. There's a phrase being used by supporters of this bill that deserves attention: restore parity between citizens and the government. That language makes some people uncomfortable, but the founders weren't uncomfortable with it at all. The entire framework of the Second Amendment rests on the idea that the people serve as the final check on government power. The militia was the people. The people were the security of a free state, and the right to keep and bear arms existed precisely to maintain that balance. If the government possesses arms suitable for infantry and the people constitute the militia, then categorically banning the militia from those arms contradicts the foundational purpose of the amendment. This isn't about recreation. It's not about hunting or sport shooting. It's about the philosophical relationship between citizens and their government that the founders encoded into our constitutional DNA. Make no mistake, if this bill passes and gets implemented, challenges will come immediately. Federal agencies won't accept this quietly. Lawsuits will be filed. Injunctions will be sought. But that's actually part of the strategy. Every legal challenge forces courts to examine the actual text of federal law. Every argument requires the government to explain why an explicit statutory exemption shouldn't apply as written. The legal battle itself could prove more valuable than the immediate implementation. Getting these questions before federal courts, potentially all the way to the Supreme Court, creates opportunities to establish precedents that affect the entire country. West Virginia isn't trimming around the edges here. They're not adjusting magazine limits or tweaking background check procedures. They're directly challenging the post-1986 machine gun status quo using the federal government's own legislation. That takes courage, legislative courage that we rarely see in modern politics. Whether you agree with the strategy or not, you have to acknowledge what's happening. A state is testing constitutional boundaries using legitimate legal mechanisms. They're forcing a conversation that's been avoided for nearly half a century, and they're doing it in a way that demands serious legal engagement rather than dismissal. The Second Amendment was never meant to preserve a hobby. It was meant to preserve a free state, and free states aren't built on permission slips from the government. This fight is moving to the states, and West Virginia just fired the opening shot. That's it for today, folks. See you in the next video.